Just waiting for a few more attendees to come in.
How many do you have?
Last time I checked, we had about 11 or 12.
That's small.
Yeah, it's small. But the recording will be put on the website as well as the different sections, just so people can get to know each section.
Gotcha.
Yeah. All right, so I'm going to get started. Good evening, everyone. I want to welcome you to today's roundtable discussion and the first panel of the Law Student Section Meet and Greet Series. This evening's discussion will feature attorneys from the Intellectual Property Law, the Entertainment, Arts, and Sports Law section, the Commercial and Federal Litigation section, and the Dispute Resolution section, where they'll be providing you with a better understanding on experience, rewards, and challenges they faced practicing, while offering insight on the various career opportunities available in each of the areas of law. During this live program, participants are welcome to post questions using the Q&A tab or the chat function in the Zoom portal. There will be an open Q&A session after each panel and at the end of the program to ask any questions you may have. So to get us started, we have the Intellectual Property Law section. We have William Robert Samuels, or Bill, as well as Brooke Singer, who will be discussing their section. You guys just want to say hello? Tell them a little bit about yourself.
Of course. Hi, I'm Brooke Singer, and I'm a partner at Davis & Gilbert in the city, and I am chair of the IP section. I have been a member of the section for many years now. I joined after attending a Women in IP event, and I saw really what a nice community it was of lawyers. I joined after that. I soon after that became a member of the executive committee and have been involved for quite a while, and I've found it to be extremely rewarding, and that it's a nice group of people that are a good network professionally. The CLEs are good. It's a good source of referral. It's a good source to just connect with people. And you know, at all of our meetings, we end with, you know, opportunities, if we know people or if we're hiring, and I've certainly done hiring through people that I've met at our events or through that network. So it's a really good source for that. And Bill, I'll let you jump in on your experiences. You're on mute. I think you're still muted, Bill.
There we
go.
There we
go. Hey everybody, Bill Samuels. I'm vice chair of the IP section. I've been a member for about the last 13 plus years, and happy to answer any questions that you all may have. What I can say is I started out my own law practice with no clients, and received an opportunity through the New York State Bar IP section to help on putting on a trademark panel. And through that and connecting with the people that Brooke just talked about, over the years was able to build a network, connect with folks, and build my practice to a place where I'm now a partner at the firm Cole Freeman and Mallon, based out of San Francisco, with an office here in New York. And what I can say is it's a highly collegial group of folks, and it's one of those types of groups as a whole, all of the members, where if you have a question, you can find an answer. Folks will help you out.
Perfect, thank you. So I'm going to start off with the first question for both of you, whoever wants to answer first. How did you decide on your practice area?
Bill, do you want to go first?
No, it's all you.
Okay, so I actually fell into it totally by mistake. I went to law school thinking that I maybe didn't want to practice law, that I was doing it because I was really interested in public policy and wanted to work at a think tank. And when I was looking for a summer position, I cast a really wide net through family and friends, and I took an informational interview at a boutique IP firm where the partner had said in advance he was just going to meet with me to tell me why I had no business practicing intellectual property law without a technical background, because I would need that because I wouldn't be able to do patents, and that was an important part of IP law. So I didn't really care that was the purpose of the interview, because I didn't really think I was interested in intellectual property law at the time. But I did a lot of research to get ready for the interview, and it seemed actually really interesting. And then when I was in this partner's office, I saw these 2 perfume bottles, and I had read he had just won a case based on those. And to me, these bottles looked a lot alike. And I knew he won the case and that there wasn't a likelihood of confusion. And so about 10 minutes into his telling me I can't really be an intellectual property lawyer, I said, all I know is I'm looking at those 2 bottles. You must be really good at what you do if you won that case. And then he spent an hour telling me about the case. He introduced me to every member of the boutique firm, and he offered me a job for my first summer of law school. So I really kind of fell into it totally by chance. And I've really enjoyed it. It's just something that it's an area that continues to grow, and the way my practice is today is very different than it was decades ago when I started, because our area is evolving all the time, and there are just a lot of different kind of nooks and crannies of IP law, and everyone can have their specialty and just find things that they really enjoy. So that's my non-traditional route into IP law.
So
Bill?
mine was, and this will date me slightly, but not terribly, I don't think. I initially thought I wanted to become an English professor. I went to grad school, I got a degree in English literature, and was going to continue on to pursue the PhD. And before I continued doing that, I thought, you know what, maybe I'm going to take a minute and decide whether or not that's, I'm ready to make that investment of time, energy, and all the above. And during that time, Napster happened, Kazaa happened, the internet really blew up, and everybody was sharing every type of media file on the planet Earth. And the question was whether it was legal or not. A lot of people were arguing that it was, a lot of people were right that it wasn't. And I decided that I wanted to get involved in that conversation. And I decided that the best way to do that was probably to become a lawyer, practice in the area, learn and understand the space. And, you know, if I hated the law, maybe I would go become a journalist and write about the area or something like that. I was then told by everybody in the universe that I was never going to be able to become an IP attorney because I had an English and history background and no science background. But I decided, you know what? I'm just going to go and do this. This is my goal. And I ended up going to law school. finding my way into an IP boutique after law school. I had no jobs or offers, and just took every contract job that I could find that was even remotely related to intellectual property. The more I did that, even though all I was doing was document review, suddenly all these firms started giving me interviews, and they thought I was a legitimate IP attorney, even though all I was doing was reviewing patent infringement emails all day. But that landed me in my first trademark prosecution gig, and I worked 24/7 for the first 3 or 4 years before the economy dropped out due to I don't know if folks might know about 2008, 2009, but it was an economic collapse. And but during that period of time before the collapse and before I was unfortunately laid off, I had learned for prosecution, and I was able to go out on my own, hung a shingle, doing trademark prosecution, and connected with some folks in the New York State Bar IP section who were looking for someone to help them with setting up a panel. That's how I got into IP, and that's how I got connected to the IP section. It was all together.
And how did this section support you in your career?
So for me, I was already, well into my career when I joined the section. I had my first job at that boutique firm for 4 years, and then I came to my current firm. And I had been at my firm for a bit at that point. I had been frustrated at that time with some of the other organizations out there that frankly were a little bit of a boys' club, and I'd go to conferences and the men were, doing deals and networking on the golf course, and I wasn't a part of that. And so I had heard about the IP section, and when I was invited to speak on women in IP and attending those events, I realized like, okay, this is something that's really different. So that was when I got involved, and I found that, it was something that was different. And I mean, not because of gender, but just because it's different. Obviously, Bill's vice chair and it's involved. But since I've been on it, my network has grown. And as Bill mentioned, you can pick up the phone and call anyone on the section, and we help each other out, whether it's a referral or a press inquiry that I have a conflict, I've sent it to Bill. Like we've definitely or I have a conflict, I can't take something on, or someone else has a conflict, and we go back and forth with each other. But also, IP law is such a wide area, and we all have different areas of expertise. Like I also do advertising law, so I'll often get a call from someone who has a question about that because it's not in their day-to-day practice. And Bill has specific expertise that I may not have, and I would feel very comfortable calling him saying, hey, what would you do here? Or do you when we were looking for a new docket program, Bill had used one that we were looking at, and I spoke to him and asked him questions because he's going to be a lot more honest about something than the actual vendor who's trying to make a sale. So it's made the practice frankly better, being a part of the section.
I would say for me, it legitimized me in the eyes of others. Being a member of the bar and working with the section from a marketing standpoint as a solo practitioner prospects saw that as, well, he must be decent if the people around him that he does CLE and other projects with are partners at these other firms. And so it kind of legitimized. And what it also did, what I would say is, there's a collegiality in a group here. People aren't competing with one another for partnership positions or projects or hours or things like that. It's everybody is kind of rowing in the same direction, looking to provide the best experiences for our membership, the best experiences for the people coming to the programs that we're putting. And so I found that by putting time and energy into sort of excellence in the programs that we were putting on and together, that had return in other ways from colleagues and acceptance onto the executive committee and responsibilities that go with that, and then referrals from colleagues that were conflicted out, and the referrals are coming from insert big name place here, and you know, that kind of legitimization in the market, you can't buy that. It really was something that developed organically, and what I can say, kind of like touching on something that Brooke had touched on, I did not find that type of opportunity, acceptance, or like consideration in a number of the other organizations that I was also participating and putting time and energy.
Perfect. Thank you so much. I'm going to open it to questions if anyone has any questions. I don't see any questions. I want to thank you guys for your time and telling us about the intellectual property law
Our
section.
pleasure. Thanks for having
Thank
us.
you guys.
Thanks, everybody.
All right. So next we will be taking a look at the entertainment, arts, and sports law section. We have Ethan Boardman speaking, as well as Christine, and I'm gonna butcher it. I'm so sorry. Latour, is that correct? Yay! Okay, and Anne LaBarbera. They will be speaking. If you just want to do a quick introduction.
I'll start. Hello, everyone. My name is Ethan Boardman. I am the chair of the Entertainment, Arts, and Sports Law section. Thanks, everyone, for being here today. I'll let Anne and Christine introduce themselves before we do Q&A, but I'm glad everyone's here today. Thank you.
Hello, everyone. I'm Christine Marie Latour. I have been a part of EASL, I believe, since 2015 officially. And I currently have my own firm, Latour IP.
Yes, and I'm Anne LaBarbera, and I have my own firm, Anne LaBarbera Professional Corporation. Not very inventive, but that's it. And I think I've been involved with EASL since 2016, I think.
Okay. Thank you. All right, so we're going to get started on how you decided on your practice area.
As for myself, I always wanted to be on the business side of entertainment. I never knew what, but I always wanted to be on that business side. And I remember, just my quick background, having dinner with a friend of mine who at the time was an attorney, and he said, you should go to law school because law school is a great background for this industry. So for those of you that are interested in doing something else with your law degree, maybe working as an agent, manager, or something in business, there's a lot of things you can do. That's one thing that got me into it. In terms of my practice area, I practice mostly transactional entertainment, representing producers and screenwriters. And what was the question again? How I got started?
Yes, how you decided on your practice area.
That's how I decided my practice area. I've always been interested in the business side of entertainment and have practiced for the last 17 years, and I enjoy it. It's a lot of fun. It's certainly a very interesting area, always changing. And I'm one of the few people who went to school specifically for entertainment. A lot of people kind of fell into it. A lot of people I went to law school with were doing corporate or real estate is what they went for school for. I knew from day one I wanted to do entertainment. So I'll let Christine and Ann take it away.
For me,
Yes. Oh, sorry. Go ahead, Christine.
okay. Similar to Ethan, I grew up in the arts, doing dance and doing choreography myself, a few instruments, a few sports, and I come from a big family of entertainers. I've been heavily involved on the creative side, and similar to Ethan's passion of wanting to be on the business side of it, just growing up around creatives, you witness a lot of obstacles that they face too when it comes to whether it's poor representation or not negotiating right terms or not having ownership over their works. Once I learned like entertainment law was a thing back in undergrad, I knew that's what I wanted to do. And then pursuing that, I learned that intellectual property is a large arm of entertainment. And that is what helped me choose. I ended up going to Brooklyn Law School, and they have a intellectual property, media and information law certificate program there, where essentially you took every IP course and clinic that they offer, and some entertainment related clinics. And that is really what drove me to want to pursue that. I did various practice areas. I did a lot of litigation before I tailored it into IP and entertainment, but landed on doing strictly the transactional side now too.
So I guess I differ from Ethan and Christine Marie that I'm a litigator. And I didn't want to be a litigator. I really was afraid to go into court, as I think almost everyone is before they litigate. So it was like, no, I'm just going to be a transactional lawyer over here. And once you start getting into litigation, you get pushed in there for one reason or another, you start to enjoy it. So anyone who's not appeared in court before, including the other lawyers here, you just lean into the discomfort. But like Ethan and Christine Marie, I was involved in the creative side of the industry first, and then moved into the the support side, the legal support side, because I was starting back in, I think it was 1992 or 1993, showing my age. I was a costume designer, a theatrical costume designer, then later a motion photographer, and I did all kinds of things in the indie film, very indie film industry, including editing. And then when I was in law school, I actually segregated that in my mind, and I got involved in commercial law. I have a master's in commercial international law, and I thought I was just going to be a boring lawyer doing commercial law. And what I realized after law school, but before getting admitted to practice, was I was very good as a producer because all of my rights were in order, all my paperwork was in order. So I had, films, because the legal deliverables for a film are actually more important than the creative deliverables. If you don't have the IP in order, nobody wants to buy your film because they have to go chase that up themselves. And there's 1,000 other films they're looking at. So then when I became an attorney, already immersed in the culture of the creative side, I realized that a large part of entertainment law really is commercial in nature. And it's very serious commercial in nature, a lot of money involved. So it's the same as if you're repping an international corporation in a big, merger or something. It's that intense and at that level, especially if you're working for a big company. So it just was kind of inevitable. One of the difference between entertainment law and other areas of commercial law is that there is a different culture attached to it. And if you don't understand that culture, you could have difficulty repping your clients. So I have regular, for lack of a better word, commercial attorneys talk to me sometimes and they say, why does nobody want to, why are people mad that my client has an attorney, right? Or why do they not want to agree to any of the terms I'm trying to bargain for? And, you find out who's the client and who's the corporation that they're dealing with. And, maybe they're like an indie comic book creator who lives with their mom and they're dealing with Dark Horse. It's like, well, your client has no bargaining position, right? And most commercial attorneys are used to a relatively even bargaining position in a transaction. But if you're repping a creative against large corporations, you just have to understand that you can't really push too hard, right? So there's that cultural aspect that a lot of commercial attorneys don't understand. So you have to both understand this kind of at times strange culture of the entertainment industry and also understand intense commercial transactions. And that's when I realized all of this went together and kind of fell into it. I do other practice areas, but if you understand how the entertainment industry works and you understand commercial law, you're almost inevitably going to fall into that.
Perfect, thank you. And how has your section supported you in your career?
I think it's been a great place to bounce ideas off people. If a client asks you to do something that you've never done before, then you have the advantage of reaching out to the members and you keep your client confidential, but everything else you kind of say, I have a client who does this. Has anyone had this problems or has had this in their contracts, or have you ever dealt with this TV network? That sort of thing. It's a great sounding board for somebody if you've never done something before, and a great way to learn and sort of have a mentor in a way. I think that's very important.
Yeah, definitely agree with Ethan. And also having such a very active section, EASL is definitely one of them in NYSBA. Like Brooke mentioned earlier, EASL also puts on amazing CLEs and other types of programming that have been not only very informative. I've learned things that I've actually taken away and used in my practice, but also, it's a great group. We co-counsel with each other as well. Ann and I work together often, and it's just a great legal family. And it's been helpful on the business side too.
Yeah, I can second that Christine, Marie, and I work together a lot. And, we pass cases back and forth sometimes, but then sometimes, we work together, we meaning all of EASL collectively. It's a really great group. And oftentimes there's a very specialized area of entertainment law that, if someone came to me and they were going to produce a Broadway show and they wanted me to be the lawyer, this is the best example. I would not take that case because it's a lot of work coming up to competence in that area. And I come from the film world and I've repped some people in the music world, but there is a person on our section who pretty much grew up in the theater. So I think his dad was a producer or whatever. He knows all about that area. So I would just refer it to him rather than wreck somebody's Broadway show. I would refer it to him. So, hopefully someday I'll be that person in some area of law that everyone's going to call me when they get a case. But in the meantime, you do have that fiduciary duty for your client not to try something you're not competent in. And EASL is a great place because there's so many sort of specialized areas of law within entertainment law. And at the same time, you have to be a generalist, but mostly that in some areas, it's just to spot issues and say, I know who to refer you to, because you can't know everything within entertainment law. And there's different cultures in these different, places within entertainment.
Perfect. So it looks like we actually have about 5 more minutes. So I'll ask you one more question. What is one misconception you had during law school about your area of practice?
It's a good question. I don't know about a misconception. Maybe it's not that you're hanging out with movie stars all day, although that's cool. And you do have that advantage of having clients that do that, but you're not really hanging out with them all day, so to speak. you're interacting with them and they're great clients and they're great people and very creative and fun to work with. But there's work to be done. You still got to draft the contracts and do the agreements and things of that nature. So that's one thing. I mean, there's a lot of fun and glamorous excitement. It's great to go to a premiere and all these things. And that's really exciting. And it's great to know that you were part of the process to help that movie be made. That's a really fun thing, being part of a creative process. But that's just something to consider, is that there's work to be done, as they say.
Absolutely agreed. It's definitely less sexy than it sounds as a law student, especially on the litigation side as well. It always sounds cool when you hear about big companies or celebrities in a specific entertainment or IP related matter, but it is definitely not fun on the back end. And similar to Brooke also, I don't have a technical science background either. I was a philosophy major. And I didn't learn until law school how much patent law was a big crux of it. And I would say it felt like a longer route to get my footing without having that patent expertise. It seems like a lot of opportunities come easier when you have that patent bar.
Yeah, I just wanted to add to, sort of to what Ethan was talking about, that, people sometimes go into entertainment law because they love entertainment, and entertainment law might not be right for them. I remember when I was a filmmaker, it's like everybody wants to be a filmmaker, but everyone doesn't want to do what you have to do to be a filmmaker. The same with entertainment law. Everybody wants to do entertainment law because they think they're going to be, having martinis with George Clooney or something like that, which is really not, not what you're doing. And also, if you are in the same room with celebrities and you think you're going to fangirl over them, you have to learn the skill of not doing that before you get into entertainment law. And there's a couple of things that you can do. For instance, you can go out to California, and the Motion Picture Academy quite often puts on events that are open to the public that cost about $5 or $10. And sometimes there will be celebrities there, and you can just get used to the proximity without wanting to fangirl, if that makes sense, or not wanting to pass out or not getting giddy or whatever. And then also, I think in general, you should spend some time in Southern California before you get into the entertainment industry, because there is a different culture there. And because the entertainment industry used to be confined really to that part of the United States, the culture of entertainment law, especially in the movies, is influenced by Southern California. And you kind of have to know, because they're different, right? So if you've never left New York City or you've never left New York State, you're going to find California to be a very strange place, and you have to get used to that culture.
Perfect. So it looks like we have two questions. One is, what should first-year law students do in preparation for entering the entertainment industry?
All right. My advice is this. First, you got to get through your required courses. I know a lot of people who say, "Oh, I don't worry about contracts." I'll take the final exam. That's fine. Unfortunately, they didn't pass and they didn't make it through their first year, so they couldn't take entertainment law and all the classes they wanted to take in their second and third year. So you still have to focus on your first year classes. You've got to get through those classes, and I enjoyed those classes. I think that's something to consider. The second thing, and related to this, I would consider is I would take as many classes in law school as you can in the areas in which you are interested. If you're interested in entertainment, take as many sports, entertainment, intellectual property classes as you can take. If it's corporate law, great, take those classes. I know that you want to take a certain classes to prepare for the bar, wills and estates, trusts, assuming they're not required at your law school. But you can also learn those things for the bar. But you're not going to be taking entertainment law for the bar or sports law for the bar. So you really should take advantage as much as you can of the classes in school, because that's where you're going to learn them. I think that's an important thing as well. Thank you.
I just wanted to add to that too. I think a lot of, I know as Brooke started out with this, a lot of this found like a different route to where we're practicing than we ever expected. And so I think as far as what you take, I absolutely re-up what Ethan said about forget about what your electives are. Just take everything that you need to pass the bar in the first year, because the multi-state bar exam basically is the first year, with all the property and the criminal and everything. But take in those electives, take what you're interested in, because some of those areas of law may put you into the entertainment industry, and some of them may push you somewhere else where you never knew you wanted to go. And I have to remember that one time, I think it was in 2018, we had a speaker at the ESOL spring meeting who was a specialist in, I think it was Article 9, because he works on a lot of deals because he knows how to perfect a lien on a copyright, which sounds like a very boring thing. But this man is working in the entertainment law area because he knew everything about Article 9 because he got excited about that as a law student, which most people wouldn't. So you never know. And I bet in law school, he probably didn't think, oh, I'm going to learn Article 9 because I'm going to be an entertainment attorney. So, that's the kind of thing that just take what you're interested in, be good at it, and you'll land where you're going to land in the profession.
Perfect.
Right.
Oh, sorry.
I was just going to add a quick note. Also be creative with how you go about trying to find opportunities. IP, entertainment, they're both less traditional areas of law. So if you happen to have connections at law firms, or being a part as a law student member of NYSBA, in our sections, getting involved in writing a paper, or we have scholarship essays every year, doing that, especially if you're taking these classes in school, you can repurpose one of your essays from school to use in one of our competitions. That's a great way to get published and stand out. And also, if you don't see an opportunity right away, you can be the first. That's how I got my first post-grad fellowship. It was with a nonprofit called Start Small, Think Big. I was their very first post-grad legal fellow, working with startups and businesses in the creative spaces. Don't be scared to seek out what you want, and it might be created for you.
Yeah. Thank you. Before we finish, also, thanks, Christine Marie. I wanted to mention this real quickly. For law students that are interested, for any law student in the New York, New Jersey area, we, the EASL section, Entertainment, Arts, and Sports Law, offers 2 scholarships, up to they're $2,500 each. You can write on any original area of entertainment, arts, sports, fashion, intellectual property, anything related to EASL. And the deadline for that is January 3rd of 2024. It's on our website for EASL. It's called the Cowan Bressler Scholarship, COWAN BRESLER. And you can take, as Christine Marie said, you can take a paper you've written for law school and resubmit it to us. We have 2 scholarships of $2,500 each, which is in a couple of months. So that's something I ask you to look into. Also, if you'd like to get involved with the section, please reach out to Amanda. She can forward you my email address. I came here about 12 years ago. I didn't know a person when I moved to New York. I didn't know a soul here. And I literally went into an EASL meeting, introduced myself, and 10 years later, so I'm chair. So it just takes that little bit to just ask. Don't be embarrassed. Don't be shy. We always find a spot for people who are volunteered. If you want to come in and co-chair a committee or co-chair an event, that's terrific. And if you also would like to write for our journal, please reach out to us and we can have someone, because if you're a law student, you have to be supervised. They just review your article, but that's another great opportunity to get published. We're always looking for articles, whether it's 2 pages or 20 pages, for our EASL journal, which comes out 3 times a year. So thanks for the little speech. Thanks, Amanda. It's appreciated.
You're welcome. And real quick, I think this is more towards Anne. Considering the prevalence of Californian culture in the entertainment law, do you recommend taking the California bar?
It's good to have that as a credential, but I think with the multi-jurisdictional practice that you may not necessarily need it. There's a lot of stuff going on in New York, and there's a lot of stuff going on, frankly, all over. Atlanta, Georgia is a big spot for filming movies. Doesn't mean you have to be an attorney in Georgia, but it depends. But I do know a lot of lawyers that will either bring in counsel if they have to, or will just go, they're okay in most states. In most states, and every state's different, please check your laws. If you're not practicing on a continuous basis and it's not in litigation in court, you're usually okay to represent that client, and considering you follow the laws there. So that's usually how it is. It couldn't hurt to take the bar, but again, frankly, taking the bars and stuff are very expensive and very time consuming. So to take 4, 5, 6, 7, 8, 9 bars, it adds up. I mean, I'm licensed in 3 states.
Yep.
So
I was just going to add North Carolina and Texas are also good jurisdictions.
Yeah.
I'm planning to, I've taken the California bar once and it is very easy to fail it. A lot of very prominent attorneys in California had to take it more than once. Eventually, I'm going to get the time to go back and do it again because I do want to be admitted in California. A lot of it's street cred and networking. But I'm also going to try to get admitted in Texas because I can do that on motion and I'm from Texas and I was doing filmmaking in Austin, Texas. So I have a lot of contacts there where I could develop a client base there. But yeah, I just wanted to add that in, but Ethan's absolutely right. The industry has spread out. So Georgia is huge. I think a lot of the Marvel films and series are filmed in Georgia, or at least partly filmed there. And North Carolina is also huge. So there's no necessity that you get admitted to any of these states, but California can help with street cred. So that's one thing to keep in mind. But yeah, you don't have to. And there's certain areas of practice, like if you're creating contracts, I don't think you have to be a lawyer, but like Ethan said, check the laws in the state you're working in. But I think non-lawyers can create contracts. So that's one thing to think about.
Perfect. Thank you guys so much for your
Thanks, Amanda.
time. We're going to move on to the commercial and federal litigation.
Thanks, guys.
section.
Thanks, Christine and Anne-Marie. Thanks.
All right. So we have Maya Riviera, Courtney. I'm gonna butcher your last name.
I got it. It's a long one. What happens when you hyphenate? Finnerty Stelzner.
And I'm horrible. Sorry, guys. Manor
NYSBA, thanks.
Yes, perfect. So they'll be discussing the commercial and federal litigation section with you. If you guys just want to introduce yourselves real quick.
Sure, I can go first. Hi, everyone. My name is Courtney Finnerty Stelzner. I am a senior associate at Getnick Law, which is a boutique whistleblower, anti-fraud, and business integrity firm. I graduated from law school in 2013. I clerked the first year out of school in the Eastern District of New York. Spent 3 years at Patterson Belknap, which is a larger corporate defense firm. And then from there, spent the past almost 6 years at this point on the other side of the V, working at Getnick Law. I'm happy to be speaking with you all today.
Hi, everyone. My name is Manor Misbah. I am a 2018 graduate of Fordham University School of Law. After I graduated law school, I clerked for 3 years in the New York State court system. 2 years on the trial court level and 1 year on the appellate court level in the appellate division first department. And now I am in private practice. I'm a commercial litigation associate at Morrison Cohen, and I am excited to speak to you all today. Thank you for the opportunity.
Hi, everyone. I'm Maya Rivera. I'm a fourth-year litigation associate at Baker Hostetler. I'm a 2019 graduate of Fordham University School of Law. After that, I did 1.5 years clerking in the commercial division under Justice Peter Sherwood, and then another 1.5 years clerking at the same commercial division under Justice Melissa Crane. And after that, I moved on to Baker Hostetler, where I became a commercial litigation associate, and that's my primary practice.
Perfect. Thank you so much, guys. So first question is, how did you decide on your practice area?
I can jump in. I decided on commercial litigation because I clerked, like Maya, I clerked in the commercial division of New York State Supreme Court. And also I was in the appellate division where I came across a lot of commercial cases. And I just found those to be the most interesting, the most challenging and complex and nuanced cases that I would come across. I came across a lot of different types of cases, but I found myself to be interested in those the most out of all of the cases that I had seen. And so I just started paying more and more attention to those types of cases and the types of attorneys that would appear before the judges that I was clerking for. And then ultimately, you know, the firm that I'm at now, Morrison Cohen, we appear very frequently in the state court system and handle a lot of commercial matters. And, it was one of the firms that would appear very often in the appellate division where I clerked. And I noticed the firm always had really compelling arguments. The lawyers were well prepared, and the briefs were well written. So that was, a firm that I wanted to be a part of. And I thought the types of cases they had were very interesting. And so I think that's sort of how I got into it, just through being on the other side of things. When you're clerking, you get exposed to a lot of different types of cases, and you get to be behind the scenes and helping the judge craft the decision on these cases. And so these cases just sparked my interest more so than others, and I just found them to be more challenging and interesting. And that's how I got into this practice area.
So I have a very similar story to Manor, which is that I got into commercial litigation through my time in the commercial division at the New York State Supreme Court. I'll fully admit that commercial litigation wasn't something that I ever thought would appeal to me. I really wanted to be a litigator, really didn't know what area I wanted to focus in, but I spoke to a lot of mentors during my 2L and 3L years at law school, all of which recommended that I pursue a state court clerkship. They thought it would be a really good experience for me. And they specifically said that if it was possible for me to get to the commercial division, to try to do so. So I was able to land a commercial division clerkship again with Justice Sherwood, who's now retired. And there, I had a great experience, actually. I didn't think, again, that I would find the work particularly engaging. I was more interested in the practice, the legal procedure, and being able to get the bird's eye view. But a lot of what my job entailed, especially when I first started, was drafting bench memoranda for Justice Sherwood prior to oral arguments. That way he could understand what was going on in a case and more or less the law that was at issue. And I found that I really enjoyed going over these sort of fact patterns, going through, complex commercial disputes, trying to break down contracts, try to understand the statutory construction of them, and trying to essentially create a roadmap for the judge. It ended up being what I thought was as a very interesting puzzle. Over time, I went from drafting bench memoranda with Justice Sherwood to drafting decisions when COVID first hit. And then I continued that with Justice Crane. And now that I'm practicing and I'm on the other side of that, so to speak, I still find it just as interesting and just as engaging. If anything, there's a lot more fact finding on this side and a lot more of that kind of puzzle-like nature of it, of trying to unpack a case and understand the nature of the conflict and what the best strategy is to convey to your audience, be that a judge or opposing counsel in some instances, or a jury, how this works and how it should go based on what the law is and how it applies to those specific facts.
Yeah, I decided, I became interested in this area of the law sort of more broadly as a law student by just realizing I was really interested in legal research, legal writing. I got very interested in moot court. And then when I had my clerkship, I decided that I really wanted to join a larger firm for a few years that had a wide array of cases on their docket, and I could use to sort of bolster my skill set and, just have a wide variety of experiences, being involved in depositions, brief writing, assisting with courtroom assistant preparation and things of that nature. After I did that for a few years, I realized that I wanted to focus more on the prosecution aspect of, prosecuting commercial fraud and doing that from, a civil litigation standpoint. And I became, drawn to whistleblower law. So, there are federal and state false claims acts under which individuals can file suit for commercial fraud. I also engage in representing corporate clients that are acting as plaintiffs. But again, I felt that you could really, in this practice area, have such a wide variety of opportunities, work on, really any subject matter can touch upon a commercial or federal litigation matter. And I thought it would be a great way to have an interesting and varied practice.
Perfect, thank you. And how has this section supported you in your career?
I can speak to that first. I think one of the most important things for young attorneys, no matter what area you're interested in, is to find good mentors who can guide you throughout your career. And the section really provides that opportunity. There's just a wide breadth of highly skilled and experienced practitioners who, if you go to events, if you engage in the listserv, you can network with. If you become chair at one point of a committee, you have access to judges who will speak at the executive committee meetings, and I think you can really expand your network in a very helpful way. So in addition to all of the great programming that this section puts on, I think the mentorship opportunities are just have been absolutely instrumental in my career.
I want to jump off of that answer a little bit by just going back to the networking as well. I really think one of the things that you'll find if you practice in litigation in any court, but especially in the New York courts, is that there's a sense that everyone there who's practicing, from counsel on each side to the judges even, that they all know each other. And the reason you get that sense is because they do all know each other. They are all peers at one point, either or mentors to each other. And almost everybody in this community, it's a small community, knows each other, and everyone has a reputation there. One of the great benefits, I think, of being a part of the New York State Bar Association, and particularly being a part of our section, commercial and federal litigation section, is that you'll get to see so many of the people who you will interact with in commercial litigation practice or in just New York State practice in general. And the fact of the matter is that there are new judges to the state and federal courts every day. And there will become a point in your career where the people who are becoming judges are your peers. And there's a real value add in being able to get to know these people outside of an adversarial setting, outside of arguing in front of somebody who is the judge or arguing against somebody who's opposing counsel. There's a real collegiate atmosphere, even amongst folks who have previously gone up against each other, especially arguably amongst folks who have argued in front of judges who are also a part of ComFed. And just being able to have that collegial atmosphere with them, being able to get to know them, it's a huge value add, because it's the kind of thing that at first may seem like, okay, it's great to know these folks, but what's the appeal? And the appeal is that one day, if you're in front of that judge, now that judge knows you, right? Or one day, if you're up against that opposing counsel, now that opposing counsel knows you. And now there's an incentive for everybody to be, doing their best, acting on their best behavior, so to speak, but also working with each other and being constructive as opposed to being purely adversarial. And the other great part about judges being a part of the New York State Bar Association is that many of them come to speak. And it's a real insightful thing to be able to watch a judge speak about a certain practice area, have them speak about what their chambers and what their chamber's operation is. I think I alluded to this earlier. One of the greatest principles of this job, I'll call it, is that you need to know your audience. And there's no better way to know your audience than being able to hear a judge talk about what they're specifically looking for when they have an oral argument, what they're specifically looking for when they're reading a brief. My second judge, Justice Crane, is a big part of New York State Bar Association, commercial and federal litigation section in particular. She has been throughout her whole career. And, she will regularly go there. When she first got ascended to the commercial division 2 years ago, I believe she went there and she spoke about exactly what she looked for in briefs, in oral arguments. That's a huge value add. I don't think you can put a price on that kind of experience.
Yeah, I totally agree. And I think in addition to that, it's really great for career advancement. I know for Maya and I both, the committee has helped us get to our current positions. So when I was interviewing for my current position in private practice, I had on my resume that I was part of this bar association, that I had a leadership position in a subcommittee. And one of the hiring partners who was interviewing me was also part of the committee. So, we had that point in common. And so she saw that obviously the fact that I have this leadership position meant that I was responsible, I was capable, I was respected by my peers and, her peers too, since she was also on the committee. And, after that, after working for a few months at my firm, she actually then approached me to take on a leadership position in another bar association committee, because she saw that I was capable of having this role and this responsibility. So having it on your resume definitely opens doors. I think it really says a lot about your abilities, your leadership abilities, your ability to handle extracurricular activities outside of a very demanding career. Obviously, law is inherently a very demanding career with long hours. I think the fact that all of us make time to be part of a bar association definitely says a lot about our dedication to law and our dedication to helping others get into the industry or move up in the industry. And I think it says a lot about you as a person and as an attorney. So it definitely, it helped me get my current position. I know it helped Maya get her current position. And then, like I said, once I did get this position, I was able to get further positions as a result. So it really is, it opens a lot of doors for you professionally and personally.
Perfect. Thank you. And what is one misconception you had during law school about your area of practice?
I don't think I had an appreciation for discovery. I think as a law student, you do a lot of legal research and writing preparation. You may even take like trial advocacy courses or depot prep. But if discovery is a huge chunk and an important one of working up a case. You got to get documents from and all sorts of other data from the other side, analyze it, put it together. If you're doing defense work, getting it out the door. And I don't think I appreciated sort of what a big part of being a litigator that can take up. I still very much enjoy the practice, but it's definitely not one of my favorite aspects of the work I do.
I'm going to go a little bit more broad and say that I didn't really know anything about litigation or what I thought I knew about litigation. I think in law school, you get a very narrow idea of what the practice of litigation is like. And you get it in snippets, right? You learn about civil procedure. And so you learn that part of how legal procedure works, how a case gets filed, how it gets brought. And then most likely you don't take any other class again that touches on it, and it just goes out of your head until the bar exam. You have to relearn it all. But even then, I don't think that a lot of these things become intuitive until you actually see it in practice. I'm really, really grateful that I got to start not just as a first-year associate somewhere, but that I got to do 3 years of clerking, because I'd say within the first 3 to 6 months, I suddenly understood so much about how the procedure works, about how a chambers operates, about how a memorandum of law is supposed to look, all of these things that in law school they touch on, they do, but it's just not done in a way that I think shows you exactly how it works. And I think to be able to see how that works is it's a completely different thing from reading several different cases to learn the history of, say, CPLR 12b6. It's completely different thing to be able to actually see what a motion to dismiss looks like and how that works, how it gets brought, how it gets argued, what the next steps are from there.
Yeah, I totally agree with both of you. I think one of the misconceptions I had was I didn't realize how broad commercial litigation is. I think when I was a law student, I thought it's probably, all about contract disputes and representing like banks or financial institutions. And that is part of it for sure, but it's much broader than that. So much of my practice includes commercial real estate issues, and I represent companies of all different sizes. It's not just financial institutions. It's there's some startups, there's pharmaceutical companies, big and small companies, high net worth individuals, or individuals from all different walks of life. So you have, it's much more multifaceted than I thought it would be, and I think that's great because every client has different needs, every client has a different budget. You have to approach each client differently. You're going to approach a pharmaceutical company different than you are with approaching a startup. So I think that makes you, able to interact with a diverse range of issues, and you have to sort of, tailor your legal advice, tailor your strategies, approaches, and your communication styles based on the type of client that you have. And I think that's a great skill to have as a lawyer, and a great skill to have as a person in general too. So I think, I didn't realize that it would be as diverse as it actually ended up being, which is, I think, a great asset.
Perfect. Thank you guys so much. I'm going to open it to see if anyone has any questions. All right, it doesn't look like we have any questions. Did you guys want to add anything else in regards to your section?
I think I would just re-up everything that I said in my second answer. I think it's a great value add, particularly if you're really interested in getting involved in litigation. It's the kind of thing that, I'm surprised that there aren't more law students who get involved early on, because I really do think the ability to have this kind of network, to be able to network with folks so easily as peers, who are, again, regular litigators in these courts, be it federal or in New York Supreme, who are judges in these courts, that's just not something I think the value of which can be overstated. So I just think it's really great opportunity. We are always looking for more young attorneys and law students to join, so that way we can help them network and help sort of pay forward what we were able to get from this experience. So just highly recommend it.
I echo everything that Maya just said, and I would add, speaking for myself, and I think also many of the other attorneys in the section, that if there is a particular area you're interested in and you see a member who practices in it, you should reach out via email. Establishing your network really can begin in law school, and I think you would be surprised at how many attorneys would be very willing to grab coffee with a law student or have a Zoom chat to talk about their careers. And you can really begin exploring sort of the nuts and bolts of like what you're interested in and establishing those connections as a law student. I know it's something that I would be very happy to do. And I think a lot of attorneys are willing to do that mentoring work as well. So just encouraging the students to reach out, both by joining the bar, but also once you do that, sort of reaching out to specific attorneys as well.
Yeah, I would echo that. I know personally, I speak to a ton of law students that are looking to work in the state court system, and talk them through the application process, or if they have any questions with their resume. I've reviewed resumes, I've helped people prepare for interviews, because we all remember what it was like being on the other side of things and applying to these positions, and it really is our pleasure to help current law students. I think, I really can speak for everyone on our committee when I say that we are very willing and open to provide mentorship, provide any sort of assistance that we can. It really is an integral part of the committee and what it stands for and what we think of as our responsibility. So we're always very welcome to helping out current law students and encouraging them to be involved, because we're here to assist in any way that we can.
Thank you, ladies, for talking and being a part of the law student chat. All right, so we're going to go ahead and move on to the next section, which is the dispute resolution section. Jill Pilgrim as well as Jeffrey Anderson will be talking for this section. If you guys just want to give a brief description of who you are, that'd be great.
Jill, I'll defer to the lady first.
Well, I thought the chair should go first, but having with that intro, I guess I have to go first. So I'm Jill Pilgrim. I'm the chair-elect for the dispute resolution section. My career has been as a tax, corporate, sports, and entertainment attorney, which dovetailed and got me involved in dispute resolution. So I am also an arbitrator and a mediator, in addition to the corporate transactional practice that I have and the sports practice that I have. So that's the short version.
And I'm Jeff Anderson, very, very pleased to have Jill as chair-elect of the section. I took over the section on June 1st. And very honored and happy to be the chair of the section for 1 year and to guide the committees and the decision-making in the section. My background is as a plaintiff's litigation attorney in typically more complex personal injury cases, a lot of products liability in my background. I began to transition to the ADR world in roughly 2008, 2009. Got interested in this thing called mediation, took some training, took some more training over time, and slowly built a practice that is really fairly focused on personal injury products, med mal, construction, labor law, MVAs, premises, mediation, and arbitration. So I'm about 70% ADR, DR. I don't want to call it ADR. I keep doing that, but about 70% dispute resolution at this point, and about 30% litigation. So glad to be here.
Perfect, thank you. So how did you decide on your practice area?
I'm going to keep deferring because I'm just was raised to let and ask the woman to go first. But Jill?
How did I? Well, I am, interestingly enough, as a dispute resolution practitioner at this late stage in my career. I am 39 years into practicing law. In the beginning, my choice of corporate transactional and before that tax was in part because I did not want to be involved in the conflict side of law. I wanted to be involved in positive energy as I looked at it, creating the deal, promoting the deal, getting things done, and protecting the interests of my clients. So I kind of, it was a little bit of a process of elimination when I was in law school, which courses I liked. The more I learned about litigation with what Jeff does, the less I was thinking that I would do that. In fact, I was pretty sure I wouldn't do that. Jeff is unusual because he is not the stereotype of a litigator. So, you know, had I met Jeff at the time, maybe I would have gone into it. But I'm happy being on the transactional side. Those were the types of courses I did well at in law school: real estate, tax, corporations. I was drawn to that. And then because I was very involved in sports, contract law was important because a lot of my athlete friends would ask me to help them with contracts and negotiations. So that's what kind of steered me to that side.
So for me, really two careers, the first as a litigator and the second as a peacemaker. And as a litigator, I didn't go into litigation thinking I wanted to be a litigator. I actually went into litigation kind of because I had an interest in this area called products liability law. Well, products liability law really led to either being a plaintiff's or a defense litigator, unless I wanted to go into intellectual property or something like that. So I think I was a guy who loved engineering, loved product design, couldn't do the math, so I didn't go to engineering school. So I went to law school, found this thing called products liability that I gravitated towards, and sort of because of my interest in that area, got into litigation. I really enjoyed litigation, but after about 30 years of it, I was bloodying my head against other defense litigators for such a long time in the courtroom and in discovery battles against large car companies and so forth. It does get tiring. And as probably anybody who's been practicing law long enough finds, there might be something else along the way that you find that interests you. And so I stumbled into the DR world and started going to dispute resolution section meetings. Before it was a section, it was a committee, and I was a fly in the wall back when the founders of this section were having their meetings as a committee. Got interested in it, as I said, took some training, and then began little by little to do mediation first, and then later arbitration, more arbitration now than I did years ago in the DR world. And it is Jill knows me as a mediator. It resonates with my soul. It's a great way to practice law. It's interesting, it's dynamic, and you're a peacemaker, and that's great.
Perfect, thank you. And how has this section supported you in your career?
Jill, you're muted.
Thank you. You think I would know how to do that by now. For me, as I made the transition, it wasn't a hard transition to dispute resolution. It was, I was doing sports, and in sports, we use arbitration to resolve a lot of the eligibility and disability type of disputes that involve whether an athlete can participate. So that's how I got into arbitration. And I didn't really know that I was doing what is now called professionally in the legal field dispute resolution. I just knew that I was helping to resolve disputes involving athletes that needed to be resolved, and that I wanted to participate because I wanted to make sure that there was somebody on these panels of arbitrators that had been an athlete like myself and could see the world in a different way than the powers that be. So I kind of stumbled into the dispute resolution section, which has been a very supportive stumble in the sense that I got involved early in arbitration with what was then the National Association of Securities Dealers, but is now called FINRA, the Financial Industry Regulatory Authority. So when I was practicing tax and corporate law at big firms in New York at the beginning of my career, through my networking, I think I met people who were involved in securities arbitration. So I was doing this weird combination of sports and securities arbitration in addition to my corporate practice. What I started to notice eventually is that many of my arbitrations, and when I say eventually, I mean 25 years later, I started to notice that a lot of my securities arbitration cases were being resolved by something called mediation. And I thought, okay, let me look into this, because for those of you who might think of practicing as a neutral arbitrator, meaning you take the place of the judge and jury, you do it for compensation. You want to get paid. So if the case settles before you have your hearing, you don't get paid because you don't have the hearing. So I said, this is impacting my revenue. Let me go find out what this mediation thing is, because if I can get paid as a mediator, and also be, as Jeff says, a peacemaker, bring the sides together, then that might be another skill and talent that I can add to my menu of services. And really, it was outreach from NYSBA, from the former chair of the NYSBA DR section, Theo Chen, who reached out to me and asked me to be a liaison from the entertainment, arts, sports law section to the DR section. And because I was thinking about getting involved and learning about mediation, and I had just signed up for a mediation certification class where you have to take 24 hours, 5 days, I decided, oh, I better, this is a good thing. I'll get to meet the people who are part of this larger world of DR, meaning the mediation side. And that just opened the floodgates. I just met all these dispute resolution practitioners who I didn't know before, didn't really understand until I joined the DR section, that there were people who made their whole law practice around dispute resolution, arbitration and mediation, or even just mediation. So that was all very new to me. And then when I took the mediation training, which was led by members and facilitated by members of the DR section, what happened is I met these great people, but I also learned that some of the skills that they were teaching I already had and had been utilizing as part of transactional contract negotiation and or peacemaking between my friends or family members. So it was intriguing to say, oh, okay, some of these things that I do instinctively or have done over time are part of a discipline that is dispute resolution, particularly on the mediation side. And I just have to say that the dispute resolution section members were overwhelmingly welcoming. In fact, I used to tell people when I joined, I think I got involved around 2019, that the DR section have the best receptions and cocktail parties of any section. So for no other reason, the DR section likes to party. So, and you have fun. In addition to learning an important skill.
Yeah, I'd absolutely echo what Jill said. The collegiality in the DR section is hands above a lot of the other lawyer kind of communities that I've been involved in. It's such a supportive group of mediators and arbitrators, and not only supportive, but viewing the New York metropolitan area and the quality of the mediators and arbitrators there, their educational backgrounds, their experiential backgrounds, they're I think clearly among the best in the country, if not in the world. And so to be among those persons, you just absorb and are shared their tremendous wisdom as well as their collegiality. And the programs that the DR section puts on are tremendous programs. They are well engineered, designed, and they are well executed in terms of the speakers, the topics, and what is delivered by way of the content of those programs. It's really tremendous educational environment for anybody interested in dispute resolution. So that's how the sections supported my career in the DR world.
Thank you. And what is one misconception you had during law school about your area of practice?
Well, I should say that during law school here in New York City, I was a Columbia Law grad. I do remember discussions, targeted at the law students to tell us about ADR at the time, alternative dispute resolution, to try and interest us in it. But I must say, as a law student, you're learning so many different things. It didn't really resonate with me what ADR was. And were I going to law school now, where I actually teach a sports arbitration class. If I had been able to take that class when I was in law school, I would have just embraced it wholeheartedly. There's so many more classes and seminars and clinics that you can take now that are innovative and different than the traditional areas of law practice that really kind of inspired should be inspiring to law students now, and you should do your best to take advantage of it so that you can get the most exposure possible and see what areas are, what piques your interest, because at the end of the day, you're going to go out into the world and do something for the rest of your life to make money. It's a good idea to be interested in it. And I love what I do. I find it so interesting. Before this call, I was preparing for an arbitration pre-hearing conference that I have tomorrow. And I was reading the contract and looking at the names of the different people and companies involved. And I can't wait till tomorrow to hear, what happened and how things broke down. And you want to, help. You want to help resolve that. So I'm not sure I answered the exact question you asked, but I hope that was part of it.
So the misconception I had in law school about the DR world, there was no DR world available to me at Albany Law School when I got there in 1978. There was, and I went back and looked, one course in negotiation. There was no course in mediation. There was no course in arbitration. The world that I entered into out of law school was a world that knew litigation, battle, expensive, long road to the courthouse. And the courthouse was the way by default that disputes involving large sums of money, very significant injuries or death in the world that I got into were resolved. It's not to say cases didn't get settled, but there was no focus on mechanisms like mediation, like arbitration, to resolve cases before they got to the courtroom. Judges had no training in how to deal with lawyers. Okay, Anderson, what's your demand in this case? All right, Anderson, go out of the chambers, go stand in the hallway. I'm going to talk to the defense lawyer. Defense lawyer, what's your offer in this case? There is no offer, or there's offer of $500,000, Judge. All right, tell Anderson to come back in, clerk. Anderson, they've got an offer of this. Is that going to do it? That's how it used to go. And so we used to settle cases if we did it without judicial help because those judges weren't trained. I'm not blaming the judges, but there simply were no mechanisms to accept mediation, arbitration. New York now has a presumptive it's called presumptive ADR, presumptive DR mediation that is now judges are trained. There are court referees, there are liaisons, there are panels of mediators who take time from their practice, who might be transitioning, who might be just sticking their toe in the water of the DR world. And so now the court system is much different than when I was in law school. So I'm very, very happy that it is. I taught dispute resolution at Albany Law School between 2017 and 2022. And the level of enthusiasm that I saw and experienced was palpable among the students. Students that decide they want to try a course in dispute resolution are very, very excited about the possibility that maybe the courtroom is not the only place where we resolve disputes as lawyers. And so that's very heartening to me.
I'd like to add one thing. One of my biggest misconceptions I realized once I started practicing law, and this isn't specific really to dispute resolution, but is that in law school, you're reading cases all the time, and you have this impression that everybody who wants a lawyer can get a lawyer. That's not the real world. I spend a fair amount of my time trying to help people find lawyers who are willing to take their case because the client doesn't have a lot of money. And when I started practicing trying to help sports people, athletes, with their problems with their contracts, most of them didn't have any money to pay. So when you're in law school, obviously the focus is on training and learning different areas of law and how to think as a lawyer. I think now there are clinics or little one-offs that you can do in some law schools that teach you about how to do a law practice in terms of building it as a business. I don't know that there are a lot of those. But when I went out on my own for the first time after practicing at various law firms, I did the work for my clients. I was so excited. I have all these clients. And at the end of the month, I prepared bills and I sent them out. And then I waited, and then I waited, and then I waited. And I learned that people are not in a hurry to write a check to their lawyer. General people, everyday people, people who are working class people, mega corporations, you know, yes, they have the resources. So to me, that's one of the biggest misconceptions about practicing law. And I tell my students in my sports arbitration class, you know, a lot of people want to be sports lawyers, right? You can represent, I tell them there's a ton of work representing athletes in sports arbitration, but a lot of it you can't get paid for because the athletes aren't the ones with the money, depending on where in the world. I deal a lot with Olympic athletes and youth athletes. So that's the biggest kind of misconception or thing that I learned practicing. And in dispute resolution, you can maybe help somebody who doesn't have money get money in arbitration or in mediation. One thing I will say that I always was drawn to about arbitration is that because of what I said, this whole issue that there are many, many, many more parties that don't have the financial resources to hire an attorney. One of the things I like about arbitration is that it's not the rules of civil procedure. It's a more relaxed, less rigidly legal rule environment. And therefore, you have individual parties or corporate parties who can walk in and represent themselves pro se without an attorney. Now, whether that's something you should do, you know, depending on the type of dispute you have is questionable. But at the end of the day, if you simply don't have the resources to hire an attorney, you're going to fare much better in arbitration than you are going to go to the courthouse and have the clerks try to help you figure out how to be a litigator. So I don't know if Jeff, you have any thoughts about that.
Well, I do, and you made great points, Jill, that there is this gap in our system that I think dispute resolution by way of mediation arbitration is beginning to help to alleviate, but a lot more needs to be done by way of compensating mediators, compensating arbitrators, and by way of enabling through community dispute resolution mechanisms and other agencies that are available, both private, not-for-profit, and public, that do try to help people gain access to the court system on a very grassroots basis, from very small claims to larger claims. But a lot needs to be done both to allow better access to persons who can't afford to pay hundreds of dollars an hour, and also to allow access to mediators and arbitrators who want to get into the field and who otherwise don't know how or don't have the financial means to go take expensive training. So a lot needs to be done for sure.
Let me also say that for the population that will watch this recorded session and or are here in person, you young folks who are out there in the world since the advent of technology taking over the world through social media and all kinds of services, you constantly are clicking and agreeing to arbitration clauses. You are clicking on all these click wrap agreements on websites, and all of them, a large majority of them have you waiving your right to go to court and agreeing to arbitration. And you're doing that, you know, dozens of times a year. And so if a problem occurs, you should be understanding that, oh, I need to go to arbitration. And if you're, you know, you're in law school, so you're being trained as lawyers, but you could actually go to this arbitration in a dispute with a big company and whether it's a consumer dispute or otherwise, and fend for yourself in an arbitration. To give you an example, last week I did an arbitration with a pro se a pro se claimant, a young woman, against a big company. So it was her against the lawyer for the big company. And I have to tell you that I had to keep suppressing a smirk because she was holding her own. She had read the cases. She was using legal terminology. She was not a lawyer. She was just a consumer who had this dispute and took the time to learn as much as she could learn. And what really blew me away is that she was confident. She wasn't insecure or afraid to say anything. And she was going up against a seasoned male lawyer, and he had a inside company lawyer with him, as well as an executive from the company. And she was by herself in her apartment, arguing the heck out of her case. It was really fun to see, and that's a beautiful thing. So having access, you don't need the courts to have access to legal remedies. Dispute resolution is another way to do it.
Perfect. Thank you so much, guys. I'm just going to take a minute to see if there's any questions.
It's a quiet audience today.
It is. So it looks like we have a question. If you have studied dispute resolution heavily throughout law school and want to go to litigation, but have not studied traditional litigation skills as much, how do you market those skills?
I'm not sure I understand the question. Is the question, how do you read it again, if you would, Amanda?
Okay. If you have studied dispute resolution heavily throughout law school and want to go to litigation, but have not studied traditional litigation skills as much, how do you market those skills?
How do you market those skills? The litigation skills, I think the question is, how do you acquire those litigation skills, right? How do you get into litigation? Is that what, maybe we could have the questioner clarify. Unless
Yes, how I'm understanding it is, and we hopefully will get clarification, the person has dispute resolution skills from law
Right.
school. How can they market those skills to get into a litigation firm or get a position maybe in litigation? Is that what the question is?
That sounds about right. That is what, yeah, they said that is what I mean.
Okay.
Yeah, okay.
Right.
Yeah.
Good. Jill, do you want to take a first stab at that?
I was never a litigator.
Yeah, so I think if you've got dispute resolution skills, if you've studied mediation, arbitration in law school, and you want to get into a litigation firm, if you want to be a litigator, then you're going to have to get some trial experience. And that's one thing that I see among young litigators, because there is much less litigation. Here's a catch-22. The young litigators in law firms, litigation law firms, do not have the kind of opportunity that I had and that young defense lawyers had in the 80s and the 90s before the dispute resolution world grew to where it is now. Put another way, the opportunities to get into the courtroom are unfortunately fewer now. And that has traditionally been the training ground for litigators. One of my partners started out in a district attorney's office. That's a great training ground for litigation. Moot court type work in law school is the beginning of the litigation training ground. You can certainly take courses, take seminars, but the reality is that when I was a young litigator, the way that I got experience was to go take a case that my senior partner didn't want to try, and I tried it. And that's how I learned as a young litigator. but those opportunities are and I talked to my defense lawyer colleagues in litigation firms about this, that they have fewer cases for their newer associates to try. So it's a tougher world to get into, despite what you've had in law school, whether it be mediation or arbitration training or moot court training. It's harder to be a litigator these days. I hope that helps at least answer part of the question.
Let me add to that. So for instance, taking my sports arbitration class in that I teach, it's an experiential learning class. So the students we spend 6 weeks learning about sports arbitration, and then we spend 7 weeks with me giving them a case, and they have to be the lawyers for the parties. So they have to do everything without my telling them what to do, as if they were lawyers. So that is like trial practice, right? That is experience in arbitration. They have to write a pre-hearing brief. They have to do opening arguments. They could do witness testimonies, witness questioning. We don't generally have that. It's more arguing the legal principles, doing the research and writing the briefs. But as Jeff said, like moot court, if you're a law student trying to get into a litigation firm, boutique or otherwise, you want to hype, I wrote these great briefs in moot court. I wrote these great briefs in the arbitration class that I took, and I argued well in the arbitration class. I got a good grade. So you want to hype that type of experience. But at the end of the day, if you truly are committed to being a litigator, you have to look for the type of firm that will give you the opportunity to do that. I know a young lawyer who now, he's younger than me. When I met him, he was young. He's married with kids now. But when I met him as a young lawyer, he told me that what he did is right out of law school, he attended St. John's Law. He went and worked for a solo practitioner who was a litigator who just threw him into everything, right? And that's how he got his practice. Now he's working in Switzerland as the general counsel of an international federation. And in between that, he was doing basketball arbitration cases. So he's really just his career went in total directions that he didn't know, because he took that chance at the beginning, because he knew what he wanted. And he said he was so scared that, that the attorney, she just threw him into everything.
They said, thank you. I asked because I wanted to do mediation and arbitration, but I understand that you need to understand the litigation process to be effective.
Okay, that's what was a little confusing about where she was going. Is it a she? Is it a woman with the question? All right. So yeah, so maybe the question is also, or a piece of that question is also, how do I get into the DR world? And that's a good question too, because it is not easy. It's like, so what's on your resume? And well, I'm just out of law school. I haven't got experience yet. Well, then why should we hire you to be a mediator or an arbitrator? And so I'll say this about trying to develop a practice niche in the DR world. There are certainly litigation firms that have dispute resolution departments. They have lawyers who specialize in mediation and arbitration. And so I wasn't aware of this up until a few years ago, but there are large firms in New York, and I'm sure other large cities, where they have a DR section. In fact, I did a mediation for a lawyer who said, all I do is mediation and arbitration. And he was with I believe a large New York City law firm. So there's that kind of opportunity. There's also opportunities to get involved in CPR and other AAA and other organizations that will get you onto their list as a mediator, as an arbitrator, to do small claims type work. There are forums and there are organizations that do dispute resolution that you can get some experience in. And there are also firms that will bring you along and have you just as a young litigator going to court with a senior litigator, take you under their wing, and show you the world of mediation, the world of arbitration. And so probably that, along with some training at some of the many courses that dispute resolution section offers and other organizations offer, would be a way to bolster that skill set so that you build that quote resume and can become a mediator or an arbitrator or both.
Perfect. Thank you guys so much. All right, so that does conclude our first panel for the law section meet and greets. I do appreciate everyone for taking time out of their day to talk to us. Here is a list of the other panels that we have going on. It will be every Thursday from October into November. If you guys have any questions, feel free to reach out. Thank you guys and have a great day.
Thank you, Amanda. Great program. Appreciate it.
Thank you.
Bye, Jill.